Hello everyone, my name is Eric Ching. I'm an attorney here in California. I specialize in real estate and business law. Today's presentation is going to be on Assembly Bill number 1482, which is more commonly known as the Tenant Protection Act of 2019. Why this act is significant? Because it basically puts in a lot of protections for tenants in California, thus making it actually more favorable now to tenants than previously. So today I just want to go over some of the basic major changes that this law does, and so hopefully it will give you guys watching this video, as well here in the audience, an idea of what your guys' protections are moving forward in California.
Use the thing to scroll.
Listen.
No. Like this. Scroll, right? Oh, I need to scroll.
Oh, there.
Oh. Do you know how to scroll on this?
Actually, hold on. The IT department helping me.
Hold on.
No.
Just pull up the email, I think the email version. This is Chrome.
Here. There you go. There, so just click this arrow.
So, as mentioned before, on October 3rd, 2019, California passed Assembly 1482, which basically does two things. It caps rent increases, okay, and it basically protects tenants from any outrageous rent hikes that might occur. Now there is a expiration date on this. In 2030 is when the law will expire unless the California legislature renews this act. Okay. So in summary, I just want to give a quick summary of what this law does. Okay. It prohibits a owner of a residential real estate property from increasing the gross rental rate for a dwelling or unit more than 5% plus the percentage change in the cost of living, or 10% of the lowest gross rental rate charged for the immediately preceding 12 months, subject to specific conditions. In essence, it basically says that, well, you can at most raise a tenant's rent 5% plus whatever the cost of living is, or 10%, and whichever the lowest number is. So if the lower number is 7% compared to 10%, then it will be 7%. The bill would also prohibit an owner of a unit of residential real property from increasing the gross rental rate for the unit if more than 2 increments over the 12-month period. So it prohibits a landlord from increasing a tenant's rent more than twice in a year, in a 12-month period, assuming that the tenant remains in occupancy of the unit over a 12-month period. It applies to all rent increases occurring on or after March 15th, 2019. So here's a couple conditions that the landlord has to follow here. 2 increments over a 12-month period, but the tenant has to have already stayed at the unit for a 12-month period, and this bill actually applies retroactively to March 15th, 2019. So if your landlord has already increased the rent after March 15th, 2019, even though this act passed in October 2019, the landlord still must follow this new act, and it's based on the March 15th, 2019 date. Okay? And this bill also says that in the event that the owner increased the rent by more than the amount specified between March 2019 and then January 1st, 2020, so if your landlord right now increased rent more than the 5% plus the cost of living, or the 10%, whichever is lower, the landlord must honor the maximum rent increase, okay, which is whatever the percentage is. So if they increase rent by more than what is allowed, you may have the right as a tenant to basically recoup whatever difference, the overpayment of rent. So we can give an example here. Let's say March 15th, 2019, your rent is at $1,000 per month. Then your landlord increases on September 1st, 2019, the rent increases to $1,200 per month. That essentially is a 20% increase. Alright, now if you look at the new bill, it only allows, let's assuming the cost of living is 2%, basically it allows 5% plus the cost of living, which is 7%. And because 7% is lower, it takes the lower of the 10%, alright? So essentially, this rental increase is not allowed. And therefore, the rent will be lowered to basically $1,070, right? And then, if the landlord would not be forced to return the extra rent paid between basically after the rental increase. Okay, so this is something that a lot of landlords these days probably don't know too much about. Now that you guys are watching this video and here in the audience, you guys will understand that if your landlord right now is trying to increase your rent, this is going to stop them from doing so. And you can tell them, hey, look, we have a new law in place right now that's going to disallow you to raising my rent, over the allowable rate under this bill.
I'm confused. Like
Yes,
your
go ahead.
example. Can you go back? It's okay. So this proposed increase in September is above the 7% threshold.
Yes.
But it's saying that it will not be lowered until 2020. Why is that?
Because the law technically doesn't take effect until
Oh,
January 1st,
so that's why.
2020.
Okay,
Yes.
but and that's why they're not required to return the extra money because
Correct.
the law is not taking effect
Has
yet.
not taken effect.
But if it was in effect at the time, then they would have had to return the money.
Correct,
Okay.
yes. Alright, this is also important that a lot of landlords will say, well, why don't I put it into my lease agreements or excuse me, not lease, so we'll go over whether this is applicable to leases or it's only applicable to month. But a lot of landlords will say, well, let me put into the rental agreement that my tenants are waiving any of their rights in this bill. Well, this bill specifically says that any terms in your rental agreement that waives any of this part of the law is basically unenforceable. It's against public policy, so a judge cannot say, oh, well, you waived your rights, so they can raise your rent however much they want. The judge cannot enforce that. So here are the existing laws currently. So I want to go over here, provide some context with currently what the landlord-tenant law is, and then give you an idea of how the changes affect this current law. Existing law specifies that the hiring of residential real property for a term not specified by the parties. So I want to emphasize this portion about for a term not specified by the parties. Because in landlord-tenant law, there's two types of rental agreements. There's one which we know as a lease agreement. A lease agreement is where you say to the landlord that I'm renting your property for 1 year. Right? So let's say hypothetically January 1st through December 31st, 2019. I promise the landlord that I'm going to stay there for 1 year. In exchange, the landlord is also promising you that for that 1 year, the rent is set. All right? They cannot raise your rent during that set. That is what we call for a specified term. So this law right now, what we're talking about is more applicable to what we call month-to-month rental agreements. This is where you tell the landlord, well, I'm not going to promise you I'm going to stay for 1 year. I'm going to rent on a monthly basis, where we don't have a set lease, that I will rent you the property, pay you rent on a monthly basis, but anytime I give you a 30-day notice, the tenant has the right to move out without any penalties. On the contrary, the landlord then also has the right to basically give either a 30 or 60-day notice, depending on the length of time they stayed at the property, to basically ask the tenant to move out. So that's the difference between a lease and a month-to-month. And it's very important to understand the difference between, because this law, this current law that has passed, the changes are only applicable to month-to-month rental agreements. Okay. Now, let's see, is deemed to be renewed at the end of the term implied by the law unless one of the parties, okay. So this part basically means, like, if I'm on a month-to-month basis, if I say I'm moving in on January 1st, right, for 1 month, and then the next month I pay rent, the landlord accepts it, that's the second month, okay? And then as long as I keep making rent, right, the landlord accepts it, it's a month-to-month basis and continues, right? And it automatically renews. That term for 1 month is automatically renewed, okay, until someone gives notice, which is what I just said, basically either 30 or 60 days notice. Here, secondly, existing law requires that the owner of a residential dwelling to give notice at least 60 days prior to the proposed date of termination, or at least 30 days prior to the proposed date of termination if the tenant or resident has resided at the dwelling for less than 1 year as specified. So this is what I was just talking about. On a month-to-month basis, if the landlord wants to ask you to leave, and if you stayed at the property for more than 1 year already, the landlord is required to give you at least a 60-day notice. If you stayed at the property for less than 1 year, the landlord is then only required to give you a 30-day notice. So this is the current law right now. Third, existing law requires that any notice be given by the owner to be given in a prescribed manner to contain certain information to be formatted as specified. Yes. In the 30-day or 60-day notice, there are certain provisions that have to be in this 30 or 60-day notice to make the notice valid. This is what it's talking about. Right now, the law specifies there are certain things that need to be in the 30-day notice or the 60-day notice.
Are you saying that there's no change to those existing provisions?
No, I'm saying that currently that is what the law is, and that the new law will make certain changes to what I just said, the 1, 2, and 3.
Gotcha.
Now, now here it is. Right now, as a landlord, if my tenant has been staying in the property for, let's say, hypothetically 2 years, I can give a 60-day notice for any reason, as long as it's not protected under, a protected class. Like, I can't evict someone because they are, bisexual or at least in California. I can't give a 60-day notice because they're disabled or have some sort of discriminatory type of intent, right? But I can give it for any reason. Let's say I want to move back into the property, as long as I give a 60-day notice, then, after the end of the 60-day notice, the tenant legally has to leave the property. If they don't, I can file what we call an unlawful detainer, or more commonly known as an eviction court proceeding. But now AB 1482 will change that. I cannot just give a 60-day notice, we call it without cause, without just cause, alright? So now it makes the landlord, if I want to give a 60-day notice, I have to distinguish it between just cause or not just cause. Because there are penalties for evicting. Well, I wouldn't say penalties, but there are certain additional requirements that the landlord has to follow if I give a 60-day notice without just cause versus with just cause. So that's one of the changes that it makes. The other change that the law changes is when you sign a rental agreement, right? Let's say hypothetically in the rental agreement there's a term saying that I'm not allowed to sublease to someone else without the landlord's approval. And let's say the landlord discovers that I have a roommate in there, or I subleased it out to someone else without the landlord's permission. Well, under that circumstances, the landlord is then currently allowed to give what we call a 3-day notice to quit. Basically stating that I want you to leave because you violated the terms of the rental agreement. You did not give my permission to sublease it out to someone else. AB 1482 also relaxes that rule and basically says that the owner, the landlord, has to give what we call a notice of violation. First, give the tenant, say, look, put you on notice that you're violating your rental agreement, and an opportunity to cure the violation, right? This notice has to be given to the tenant, informing the tenant, say, look, you have subletted this out without my permission, all right? And give, say, a time frame to basically fix this problem. And then, and only then, if they don't fix the problem, then can you give a 3-day notice to quit, to proceed with, evicting them for violating some of the terms of the agreement. Okay.
I'm sorry, I think I missed it. What is the time period that they have to cure the issue?
The notice of violation, the law doesn't specify very clearly on the time frame.
So the landlord sets the time
The
frame?
landlord does set the time.
So they can set a time frame of 1
Yeah,
day?
correct. It's a little relaxed on that, but yes. But then keep in mind that they also have to give another notice. Right? So if the violation is not cured within the time period set forth in the notice, 3-day notice to quit without opportunity to cure may thereafter be served to terminate the tenancy. So now it makes it so that the landlord has to do a 2-step process. They have to first give a notice of violation, then, and only then, after the time period set in the notice expires without curing the violation, can the landlord give a 3-day notice to quit without the opportunity to cure, right, to terminate the tenancy. And then after the 3 days expires, then you have the legal right to file an eviction against the tenant.
Seems like with that first notice, you can totally just skirt around the new law.
You can, and again, with all new laws, there will be subsequent, clarifications from the legislature as to what they really wanted in this notice of violation. It's very unclear based on the reading of the language currently on the bill. So we'll see what happens with that. But as you know, as all law students know, that when you have the legislature draft something can be very difficult to interpret or very, very ambiguous, and it leaves it up to the courts, the appellate courts, to provide some guidance as to what exactly was meant when the legislature drafted the bill. Okay, so here's where the key, I think this is probably the major change to our California law, is that let's say your landlord gives you a 60-day notice because they want to move back into the property. This is considered a fault, just cause, because the tenant is not at fault. The tenant didn't do anything wrong. You can't blame the tenant for you wanting to come back into the property to make it, your home anymore. So because recently a lot of landlords have said, well, I want to move back in, so leave, right? Give you a 60-day notice, and then that would be totally fine under current California law. The bill would require that the owner either assist the tenant to relocate by providing a direct payment of 1 month's rent to the tenant, or waive in writing the payment of rent for the final month of tenancy prior to the rent becoming due, regardless of the tenant's income. So this is the major change that a lot of landlords right now are kind of freaking out about. Okay? Because if I want to get my property back, because I want to move back into it, I also have to follow this new law and essentially pay my tenant 1 month of rent, or waive 1 month of rent, okay, to assist them in finding a new place. So I have to pay additional money to the tenant because I want to move back into my own property.
This is in addition to already giving a 60 or 30-day notice.
Correct, yes. This is also, so by law right now, or starting January 1st, 2020, alright, if the landlord gives you a notice for no fault, just cause to ask you to basically leave the property, whether they wanna remodel it, whether or not they want to move back into themselves, for any reason that is not a just cause, the landlord will then have to pay 1 month's of rent or waive 1 month's of rent to the tenant.
Does the bill specify whether this notice for no fault just cause, does it specify whether the landlord has to inform the tenant of this right, that they could receive
Yes, it does.
the extra rent?
Yes, it does. Yes, it does. So by law now, even in the 60-day notice or 30-day notice, you have to put into the notice basically informing the tenant of this right, that they can ask for waiving of the rent or payment of 1 month's rent. Okay, so what is a no fault just cause? Let's get delve into that because it includes intent to occupy the resident property by the owner or owner's spouse, domestic partner, children, grandchildren, parents, and grandparents. It used to be that I would always advise my clients basically, alright, well, the easiest way to ask the tenants to move is basically just let the tenant, to give a reason, is to let the tenants know, well, I wanna move in myself, or some relative, a spouse, domestic partner, grandchildren, someone related to me wants to move back into the property. And it's fine, after 60 days, legally, the tenants have to move out. Now, this category, if you use this reason on your notice, you will basically have to pay your tenants, 1 month's of rent or waive 1 month. And the legislature designed it to be like this because, like I said, in recent years, there has been a flood of notices given to tenants asking them to leave. And then, like I said, California, for any reason, you can give a 60-day notice. But now the legislature really wants you, if you really are intending to occupy it for yourself or for one of your relatives, alright, then you're gonna have to pay. And this basically ensures that you're not actually just lying to your tenants and telling them, hey, I'm gonna move back into my property. Because a lot of times they tell them that, and then a couple of months later, they actually just rent it out to another person for much higher rent. And so that was the main reason why they wanted to evict the tenant, not because they actually wanted to move into the property themselves. So this law is designed to prevent that from happening. Okay. Also, no, withdrawal of the residential real property from the rental market. So it says, well, Mr. Ching, why don't I just kick them out and leave it vacant? Alright, then we can just not do the rental. Well, this also falls into no fault just cause. So you cannot basically just leave it empty anymore. If you tell it, I'm just gonna leave it empty, you still need to pay the tenant 1 month's of rent or waive 1 month's of rent.
Maybe you'll get into this later, but what if you want the tenant to vacate the property for reasons that you haven't covered? Like they didn't break a term of the lease agreement, so the 3-day notice to quit doesn't apply, and it's not a no fault just cause reason.
Sorry, say that, ask that.
Like maybe they wanna rent it out to a friend.
Oh, yeah.
If they want to rent it out to a friend,
Yeah,
well,
which-
that's still considered a no fault just cause. Because it's not the tenant's fault.
Okay, so it's not just limited to those two categories.
Right. The intent of the legislature when passing this is basically classifying no fault just cause that, yes, we know that the landlord has just cause to ask the tenant to leave, but no fault. It's not the tenant's fault. It's not because the tenant failed to pay rent. It's not because the tenant violated a term of the lease or the rental agreement. It's not because the tenant did anything wrong. It's just, I as a property owner have the right to have my property back or rent it to whoever I want. That we all know. That's basic real property law. It's my property, I can do whatever I want with it. So the legislature designed this law saying, wait, it allows you to do whatever you want, but you're gonna pay the tenant, you're gonna assist them to relocate, alright? So this is basically to ensure that the landlord isn't playing these type of games to try to rent it out at a higher,
To skirt
monthly
the
rent.
rent control.
correct, to skirt the rent control laws, right? Because remember, if you have a tenant in there right now on a month to month, the maximum you can increase the rent is, was it 5% plus, or 5% plus the cost of living, or 10% for the minimum? So if I'm a landlord that says, well, if I have a tenant right now that's paying, very low rent, and I can't keep moving up like 20%, 40%, right? Then why don't I just give a 60-day notice? Well, now the law is designed to prevent that from happening, cause there's always loopholes, and this is one of those provisions that prevents that type of loopholes from happening, is that, fine, give a 60-day notice, but you're gonna pay relocation costs or benefits, assistance to the tenant to be able to relocate. Okay? So, continuing OJA, an order issued by the government agency or court relating to habitability that necessitates vacating the residential real property. This is actually really important. Alright. If, then a lot of landlords are, I'm just gonna not do any maintenance on the property and just let it fall apart. It's raining right now, there's a roof leak, I just, whatever, okay? And then the tenant will then basically stop paying rent, and then boom, you can get, then once the landlord, you then can do what we call a just cause eviction, right? The tenant didn't pay rent, but then because the tenant stopped paying rent because of habitability issues, okay, the court can order basically saying, well, it isn't a just cause eviction, it's a no fault just cause because you didn't maintain the property, you violated what we call the warranty of habitability, which is basically certain requirements that the landlord has to provide to the tenant, so as a habitability to make the property habitable. Okay, so in this case, the tenant can also, because it's a no fault just cause, can also ask the landlord for relocation benefits. An order issued by the government agency or to the court to vacate the residential real property. So if the government tells you that the tenant tells the tenant to have to leave, even though this isn't the landlord telling the tenant to leave, the landlord in this case is still obligated to basically pay the tenant's rent relocation benefits. Here's something that is important to point out. Certain cities and counties in California have their own localized rent control, or probably even more severe than this law that's recently passed. For example, city of San Francisco. If you look at the local ordinances in the city of San Francisco, it is extremely difficult to kick someone out. And because it's so difficult, and because the law is so strict against the landlords, that law will actually trump this law. So if you have a law that is more severe, then that's the exception to this rule. So it says, if it's determined by the government agency or the court that the tenant is at fault for the condition of continuing, shall not be.
Yeah, that's a caveat.
Oh, that's a
Sounds like
caveat, sorry, that's a caveat, but basically the local ordinance that necessitates vacating the residential real property. So if a local ordinance says that they need to vacate, it's also considered a no fault just cause. Okay, here's where I mentioned this before. You want to substantially remodel. Okay, a lot of tenants will, what if I want to remodel the place? Okay, can I then ask the tenant to move out without having to pay a penalty? No, because the law then accounts for the situation. And it also defines what substantially remodel means. The replacement or substantial modification of any structural, electrical, plumbing, or mechanical system that requires a permit from a government agency or the abatement of hazardous materials, including lead paste paints, and it defines those. Cosmetic improvements alone, including painting, decorating, and minor repairs or other works that can be performed safely without having the residential real area, do not qualify as substantial rehabilitation. Okay. So the only time when it's considered a no fault just cause is when you do a substantial remodel to ask the tenant to move out. Cosmetic improvements is not a substantial remodel, but at the same time, cosmetic improvements, say, well then, how about I need to paint, the bathroom, and then ask the tenants to move out, well then, no, you won't be able to, because it's a cosmetic improvement.
So in that case, if you wanna make a cosmetic improvement, you cannot have them move out?
You cannot have them move out.
Oh,
You
just
would be
for the-
violating the lease agreement
Correct.
in that case.
Correct.
Just for the emergency, like a repairment, then you can ask them to move out, right?
Yeah, you can ask the tenant to temporarily relocate, for example, there's a major leak in the property. You can temporarily ask them to relocate out, but it's not asking them permanently leave.
And it would be at your cost, at the landlord's cost.
Or it would then, depending on what the rental agreement states, there are certain provisions that says that in the event of a leak occurring that isn't the landlord's fault, like I said, plumbing issues happen all the time, floods happen all the time, so if it's not the landlord's fault, you can, basically, the tenant is allowed to have what we call a rent abatement, basically for the duration of the time that the tenant has to leave the property for the repairs to be done, they would get a credit against the rent that they paid for the time that they had to leave. But again, keep in mind, temporary relocating versus permanently kicking someone out is very different, okay? So you, in a situation where you can temporarily relocate, your obligation is basically only providing the tenant a rent abatement for the duration that the tenant has to leave the property, you would credit them on a per diem basis, per day basis, based on how much time they had to leave the property to get the repairs done. So here's a question was just asked about what does the landlord have to inform the tenant of their rights in terms of relocation benefits assistance. And the law that says, if an owner issues a notice to terminate a tenancy for no fault just cause, the owner shall notify the tenant of the tenant's rights to relocation assistance or rent waiver pursuant to this section. So ideally, what we have done now, such as our firms, all our notices have basically boilerplate sections listing like, note, you have these type of rights in the notice so that it complies with this new law. Okay, so this basically satisfies that my notices have informed the tenants of their rights to relocation assistance. Okay. Now, you're saying, well, this is very strict against the landlord. The bill also does provide some protection for landlords, whether or not you wanna say it's equal protection, that's to be debated, but the bill also says that the bill would require the actual amount of relocation assistance or rent waiver provided to a tenant that fails to vacate after the expiration of the notice to terminate the tenant to be recoverable as damages in an action to recover possession. So let's say I give you a 60-day notice, I also pay you the relocation assistance, but at the expiration of the 60-day, you decide to still stay at the property, forcing me to have to file an unlawful detainer, an eviction case, to kick the tenant out. At court, I can basically say, look, I paid you the relocation and you still stayed, and I can basically recover those as additional damages against the tenants for taking my money and not using the money to help you move to a new property. Okay? But this would have to be done at the unlawful detainer stage in a lawsuit against the tenant to get possession back of the property.
So you're saying the tenant could forfeit their right to relocation assistance benefit?
Yes.
If they decide not to vacate after the
Correct,
notice?
but the right is not automatic. You can't just take the tenant's money, you still have to go through the court process to recover it. The judge has to agree to it, and in a court order will say, yes, you have, that money. Now, then you can get into that, well, can I collect against the tenant? A lot of times they would take this money and probably use it to buy a new TV or something like that. Well, this is where the argument of whether this is fair to landlords, because the landlord is still forced to go through the court procedure and still have to collect against the tenant. And usually in this situation,
The tenant that's not paying rent.
correct, a tenant that is still basically squatting in a property and is not using the money toward a new place, probably doesn't have the ability to return the money that you already gave in rental assistance.
So you said that this bill applies to month tenancy.
Month to month, yes.
So in a case of a lease where you have a set term, when you renew that term, the rent control threshold or the cap on the increase in rent doesn't apply.
Okay.
They can rent it out at fair market price.
Yeah. So here's where I think the loophole is, and I don't know, again, a lot of times new laws are written and then there's gonna be, interpretations or certain things that need to be changed.
I think we were on the last slide anyways.
Okay, well, anyways, what will happen is if you're on a month-to-month rental agreement, lease agreement. Let's say you moved in January 1st, signed a lease agreement with the landlord, and the lease expires December 31st, 2019.
So 1 year.
So 1 year lease. When the lease expires and you pay rent on January 1st, 2020, and the landlord accepts it, your rental agreement, your lease agreement automatically converts to a month-to-month, and at that point, this law applies. Let's say your original rent was $2,000 a month, leased, and then on January 1st, your landlord basically, you pay same $2,000, you never renewed the lease, you paid, and then the landlord accepts it. That means you are automatically converted to a month-to-month lease rental agreement, and then this law, in terms of the rent control, applies. So from January 1st so forth that you paid the $2,000, your landlord cannot increase, there's a rent cap based on the increase.
So in a lot of cases with students and people such as myself who rent in San Diego, we sign a lease with an apartment complex for a year, and then getting 30 or 60 days close to the date that the term expires, they say, hey, you can renew this lease for this price, or you can rent month to month for this price.
Yes.
That price for month to month is the cap applied to that price that they're quoting.
No.
Or no, they can just quote whatever they want.
Yes. Because a lease agreement is basically a termed period that you're promising the landlord, and the landlord's promising you that you're gonna stay for that 1 year, and the landlord will not increase, right?
Mm-hmm.
During the lease, the landlord has no right to increase the tenant's rent.
So that quote they're giving is like a quote for a new lease, a new agreement, and if you don't agree to that new price, then you can't live here.
You can't live here. So if, most of the times, yes, the landlords will give you two options. You can renew the lease. Usually it's gonna be lower than the month-to-month price, because if you renew the lease, you're promising the landlord that you're gonna stay for a year. This is beneficial to the landlord because the landlord doesn't have to worry about all of a sudden getting a 30-day notice and then the tenant moving out, and you have to spend time and energy to find a new tenant. Alternatively, you can choose the month-to-month option with a higher rent, okay? And then the higher rent is because you as the tenant have the right to give a 30-day notice to move out at any time, but at the same time, the landlord has the right to basically increase your rent. But now, if you accept the month-to-month basis, the landlord has to follow this new law in terms of any subsequent rental increases. So it's capped, like I said, at the 5 plus 2% or the 10%, whichever is lower. So how this law will affect the landlord's thinking in terms of, well,
When they first set up their quote.
yeah. If I'm a landlord and I sign a lease with my tenant, I have the option, I actually have the option not to offer a month-to-month rent option, right? I can just say, well, you gotta sign a new lease at this price. And if you don't accept, please move out. Okay? So whether this law will create basically change the landlord's thinking in terms of whether or not I want to offer a month to month is to be seen. I don't know, and it's hard to predict, what the landlord's done, but you are absolutely correct right now. Right now, at least, the landlord's team seems to be okay with month to month and with a higher price. Whether or not they will, at the expiration, make it so that if you want in month to month, it will be an even higher price now.
Yeah, I feel like this might cause a market reaction that's adverse to what the bill intended, right? Which is
Absolutely.
because everyone's now going to start increasing their rent, their monthly rent. Landlords are to account for not being able to for those just cause terminations and all that, and so I think overall rent will increase, which is
It could be a possibility. All economists that I have, talked to about this, as well as read articles, always say rent control is not the way to go. One, it decreases the volume of rental properties in the market because, like I said, landlords are saying, well, I don't have the ability to control my property. And in fact, now, if I want my tenant to move out on a month-to-month rental agreement, I have to pay the tenant and relocation assistance. This is gonna be frightening to a lot, especially smaller landlords with, private landlords that are that have maybe one or two properties out there, and they're gonna be like, well, I might as well just sell my real estate out, and not put my house on the rental market. And to put some context, this bill, okay, we in California as voters voted to see whether or not we wanted rent control. We as Californians voted down. It was a proposition, I can't remember, I believe it was in 2018, there was a proposition on our ballots basically asking, do we want rent control? And the majority of Californians said, no, we do not want rent control. Then because of that, our legislature, state legislature, still decides to basically put this bill in place and pass it, basically still implementing rent control, despite the majority of the population of California voting down. Now, given what we voted on, the proposition wasn't this exact bill, but it was still a blanket, do we want rent control or not in California? And it seemed like the majority of Californians said they don't want. And because of most majority of economists does agree that rent control does actually have an adverse effect in increased rent rather than decrease. So it actually has a adverse effect to what it was trying to, in the intent of basically lowering rent. So
it really just helps people that are currently renting on a month-to-month.
It does.
And if they ever move out, then it might hurt them.
Right, so what we will see is probably more tenants staying put. You won't see a lot of movement around. Maybe students, particularly because students are the ones that move around quite a bit, will probably get hurt by this. Landlords are probably gonna be more reluctant to offer month to month and will probably insist on lease renewals. I don't know how it will affect the pricing of the leases renewals, right? They will have to think about, well, if the tenant doesn't agree to the lease renewal, I will then have to find a new tenant, then have to sign a new lease, and then they would have to weigh in terms of how they would price their rental unit. So in general, it's hard to really predict how this will affect the market, the rental market, because this law is pretty unique to California. There isn't a lot of rent control. I believe out of the entire nation, only 7 states have actual rent control, and this particular bill, I believe, is fairly unique to California. So it'll be interesting to see come January 2020, 2020, to see what the market does in terms of rent. But I do know, at least for now, our office has been getting quite a bit of inquiries about should I kick out my tenant now and not have to worry about this. So, and having been in eviction court recently, there has been a flood of a lot of evictions going on. So it could be a sign that a lot of landlords are really, not okay with this law and trying to take their property out of the rental and sell it before this law takes place. So we'll see what happens.
When did you say that this bill is valid till?
2030, so it's a 10-year law. And then now it's interesting, in the bill itself, it does put in requirements that that the legislature has to make reports to see what's going on. So the legislature is also aware that they don't quite know how this is going to affect the market, and there will be reports, I think annually or biannually, reports to the committees that oversees handling this law to see what the market is doing. And the legislature has the option to repeal it if they decide this isn't working and has a detrimental effect on our rental market. So we'll see. It's definitely interesting, and it's definitely something that I believe we should all be paying attention to. Thank you very much.